The Supreme Court today arguing a case about the president's travel ban. Now, it was intense reportedly and heated, and it looks like it will be a close decision once the judges make the call. Now, here to walk us through that and the latest DACA case as well, Brooklyn Law School professor William Araiza. All right, let's break this into two parts. And first, let's start off with the Supreme Court today and what at least we can kind of divine from the argument. It seems at least along normal lines, with Kennedy being the swing vote as usual, that they're willing to, in effect, say that the administration can make their own determination, that this isn't really about discrimination, this is about national security, and that's usually not their role to get involved. Did you kind of read the tea leaves the same way?
Yes, I think so. There was hard questioning of both sides, but I think there was a great reluctance on the part of the court, in particular, as you said, Justice Kennedy and Justice Roberts as well, to be sure, about second-guessing the executive branch when it comes to the president's national security determinations.
You know, there was one questioning from what seemed to be the dissenting side, Justice Kagan, where she said, let's do a hypothetical. Imagine we have a virulent anti-Semite for a president, and he decides that he's going to ban anyone coming into the country from Israel. Would that be constitutional? The argument, at least from the attorney presenting the case for the travel ban, said, well, yes, because this is, again, a national security issue, and you give deference to the administration. I'm surprised. Really? Is that how much discretion the court would view? Any discrimination is okay as long as you say it's in the name of national security?
Well, it's something that I think the government's lawyer had to say. He had to give that response, because if he responded differently, then the door would be open to some level or quantum of evidence that might justify second-guessing his national security determinations. He had to hang tough. He conceded it was a tough hypo, but I think he really had no choice but to answer the way he did.
So is there any line, Professor, as to where discrimination begins and national security ends?
Boy, it's hard. The Israel hypo, I think, really cut to the core of it. If you have that sort of explicit bias that the candidate and then the president expressed, and then you turned it against the one country in the world that was predominantly made up of those people against whom he expressed that bias, and still the government says, you know, you have to go with the president. If that's where the court goes on this, then it's really hard to see where the president doesn't have the authority to act on bias. It's very troubling.
Now, I want to get to the other potentially development as it relates to another major policy. I'm talking about DACA, and I want to read what the judge had to say here. The administration's decision to terminate the program on the, quote, virtually unexplained, end quote, grounds that the program was unlawful, and the decision to phase it out was arbitrary and capricious because the government failed to adequately explain in its conclusion that the program was unlawful. In translation, at least my reading, and I defer to you on this, is they say you didn't get your act together here. You came in front of us. I'd almost be willing to give you the benefit of the doubt, but just saying it's unconstitutional isn't enough. You got to explain why. It's pretty shocking in the third go-round, Professor, that they still haven't made their case. It seemed, by the way, a Republican-appointed judge, he was willing to go there, but they didn't make any argument as to why.
Yes, it is rather shocking. Look, it's a foundational requirement of administrative law that government agencies, for example, the Attorney General, the Justice Department, that they explain their decisions. And the fact of the matter is the DOJ simply did not explain this decision adequately, even though it surely had advance warning it was going to be asked to do so. It's rather surprising, but part of a general pattern of this administration to not have its ducks in a row when it takes administrative regulatory action.
You've already had two federal judges on DACA say no to the president, and this would be the third bite of the apple, although 90 days is the window that the administration has to represent the case. But it does open the door here a little bit, doesn't it, if you're a DACA recipient where they say, or a qualifier, that you can now apply. There is an opening, or at least a hopeful sign, if you're a dreamer out there.
Yes, well, that part of the decision was, I think, what distinguished the decision today from the earlier ones you referenced, but the decision today, as you noted, was stayed for 90 days. And so DACA recipients can't start reapplying immediately, but this is certainly a very hopeful sign for them.
You know, I get to the point you made just a couple minutes ago, which was there's a pattern here. And if you can explain from a historical side, it doesn't matter, Republican, Democratic administration.
That's right.
You have some of the best and the brightest that are crafting, arguments before the court. It's never when you see something going to a federal court, a Supreme Court, that they basically are trying to, if not make it up on the fly, don't really have their ducks in a row. We don't see this, do we?
Not often at all. And you're absolutely right. This is not a partisan issue. This is not a Democrat-Republican issue. Most administrations in recent history, until this one, have had their ducks in a row, by and large, when it came to taking regulatory actions. This is not the first time that the Trump administration has stumbled, and by all indications, it's not going to be the last time either.
Well, whether it relates with DACA or the travel ban, we'll continue to follow it. And as always, Professor, I really appreciate your time. Thank you so much.
Thank you.
And coming up next, we switch gears. We're going to meet a victim of sexual assault when he was a young boy. And we're going to talk about his search for justice with he and his advocate and why it's so hard with the statute of limitations for these folks to find the justice they deserve.